Hi there. There are situations where a family court will appoint guardians for children, where a child is without a parent. The court might appoint a guardian, where, and normally this is done on the application of someone who is interested in being the guardian, where the particular parent is probably not fit to be or is not acting in his role as a parent for whatever reason. An applicant can bring such an application to be the guardian of the child. When you're a guardian, you basically have the power to do anything a parent can do, and you can apply for anything that a parent can apply for the child, the best interest of the child. In such situations, you obviously bring an application, and that application is then it is supported by a barrage of evidence that you have to bring. For instance, you would have to bring, in such a situation, you would have to bring everything that's connected to you. Can you pay for the child? In the situation where you can pay for the child's expenses, you bring your employment letter, maybe pay slips showing that you are gainfully employed and you are being paid, so you can obviously foot the bill for the child. Where you live, your utility bill, to show that you actually live in a place that makes sense. In such a situation, the court might even order that welfare services or child protection services of that particular local government where you live, go to check your house and see that everything is in order and stuff like that. So in such a situation, you would have to provide that. You have to provide obviously your ID to show that you are legitimately living where you say you are living, and that you're legitimately maybe what you say you are as far as identification goes. The child would have to provide his birth certificate, because in guardianship, a child can only be a ward, so a guardian, till the child is of that age of legal independence, which is 18. Anything after 18, the guardianship ends. So anything before 18, well, you have to obviously bring a birth certificate of the child, who is called the subject, to show that that child is worthy of being a ward, and you can be a guardian to such a child, because after 18 is assumed that that child is no longer a child and is an adult. The other thing that you will bring, the parents in such a situation, if the parents are alive, it's always advisable that the parents also file a statement or an affidavit saying that they do consent to the fact that, to the applicant being the guardian of the child. In such a situation, they would probably bring, obviously apart from the affidavit, maybe their ID, obviously passports and all that, to show that, passport photograph to show that the consent, and they would normally even, it's advisable because they would be made respondents in such an application. So it's always advisable that they also show up on the day of the hearing to say, okay, you know what, we are here, we consent to this, we have no problems with this and all that. Sometimes they will ask why, and obviously there should have a feasible reason why they want to do that. Most of the time, such reasons, maybe they can't take care of the child. This particular person has always been taking care of the child, which is part of what the court will consider when the court wants to give grants the order for guardianship. The court will look at the relationship between the child and the applicants, and maybe even you, the family that's a respondent, father and mother. They will also look at if you've been making what you've been contributing towards the upkeep of the subject in the past. Now, what sort of relationship you have with such a person, probably your standing, just to make sure that you have no sort of illegitimate job or whatever you're doing that would then impact on the child, because obviously what is looked at is the best interest of the child. So if the court sees that the applicant would provide better care or better livelihood for the child, then that would be a good point for the court to grant guardianship orders in that situation. Obviously, there are situations where a guardianship order can be revoked, and I've mentioned one of it, which is where the child turns 18, or if the child maybe brings an application to that effect, or even the parents of the child say, you know what, I don't like what's happening, maybe I can't see my child, this person has just taken over my child and is not granting me audience with my child anymore and stuff like that. In such a situation, you can bring an application to revoke that guardianship order. But by and large, A guardianship order is done where that parent is not available, is dead. The child, sorry, this child parents, the parent is dead, or the parents cannot do anything. Maybe is not fit, or maybe cannot provide for the child because there has no money, or maybe if lives far away and doesn't want to come back. Anything of that nature can evolve, or maybe the child does not have a place, a residence that he even stays. In such a situation, such guardianship orders can be granted. Even the court can decide to grant a guardianship order without the application of the person in such a situation. Well, that's all for guardianship. There's many, obviously, there are many more things to guardianship. In such a situation, it will be advised that you contact a lawyer. Like to pay for that legal service so that the lawyer can put you through most of what you need to know about the guardianship process. My name is Mubarak Bemi. Thank you very much for listening.